Hi, I'm Luke Nichols with the law firm of Nichols & Green, and I'm excited to talk to you a little bit about how we defend reckless driving cases. I really enjoy defending reckless driving cases. It's something that I've really made a career out of, and it's something I really love doing, and I'm excited to talk to you a little bit about today. But first, let me tell you a little bit about myself. I spent my entire career defending reckless driving cases. I defend traffic cases, criminal offenses, but reckless driving and DUIs are the most of what I do. I've written several books on Virginia traffic and criminal law, including the Virginia Reckless Driving Handbook. And I've also gone through the police training for speed enforcement. So I've gone through the same training that law enforcement officers go through to know how to do radar and LiDAR and pacing. It's a 18-hour NHTSA course. I've also, here in 2015, completed the instructor's training course that certifies me to be an instructor for police speed enforcement. So these are things that I really enjoy doing. I also have an engineering background, and I collect police radar and LiDAR, and I enjoy figuring out how they work and what makes them work right and what makes them work incorrectly, and it's something I spend a lot of time doing. Here at Nichols & Green, we also represent about 300 reckless driving cases each year. So we see a wide variety of reckless driving offenses, everything from the very mundane to the very serious. And we're usually in court almost every single day representing somebody on reckless driving charges. I've represented a lot of people on reckless driving cases over the years. I mean, hundreds, but there's some really interesting ones. But two cases that really stick out in my mind as being kind of extreme examples. The first was a case that we successfully defended, and that was a case where a gentleman was accused of driving his car in excess of 100 miles per hour in a 25 mile per hour zone. The car allegedly lost control and hit the curb and became airborne. And when the police arrived on the scene, the car was found half in, half out of a house about 3 feet off the ground. And that was, fortunately, no one was hurt severely, and it worked out well. And I've also more recently had a case where a gentleman was accused of reckless driving by speed for going 150 in a 55, and we were able to protect him from and avoid a criminal conviction for reckless driving, and so that was a very rewarding case. But it's important to remember with any of these examples that just because we won these cases, that doesn't mean necessarily we're going to win any other case. If you want to know what the likely outcome of your particular case is and what we can do for you, just pick up the phone and call. We do free consultations at any time. You can call over the phone or talk to us in person. We'll hear the facts of your specific case and tell you exactly what we think. We do hundreds of these cases, so quite quickly we're going to be able to tell you exactly what you're facing, what defenses are available, and what we can do for you, what the likely outcome is. Basically, there are two strategies that we use in defending any reckless driving case. One is we attack the facts of the case. We try to show how the prosecution can't prove beyond a reasonable doubt that the driver was guilty or this person was guilty of reckless driving. The second strategy is more like throwing yourself at the mercy of the court. We show why the person should not be convicted of reckless driving. We try to explain why they're a good person, why they're a good driver, why this was a fluke. The type of things that make the court want to show mercy to a defendant. So we attack the facts of the case, and we try to get the court to show mercy. Those are the two main strategies that we implement in any reckless driving case. There are basically three ways that we attack the facts of a case in a reckless driving case. If we're going to go to trial and try to show that they can't prove beyond a reasonable doubt that my client is guilty, there's three strategies we use. Now, these are highly technical areas of law. It's something it's easy to talk about, it's difficult to do. And so it's not something that if you're thinking about representing yourself or going in on a speed case and trying to defend yourself, these strategies often don't work very well by yourself. They're hard to do. I don't think I've ever seen an unrepresented defendant successfully win a case, a speed case this way. I'm sure it's happened, and in other jurisdictions it might be a lot easier, but here in Northern Virginia, it's not impossible, but it's difficult. It's very difficult. It's even something that's very difficult for a lot of lawyers. I know when I first started getting into aggressively defending these speeding cases and reckless by speed cases, my first few trials, some of them didn't go super well. You know, there was a steep learning curve. A lot of things go wrong. Okay, so it takes a lot of experience and trial and error and just spending a lot of time learning to get proficient at these. So if you're on your own, these aren't strong defenses for somebody without experience. But it's good to understand them so you can understand, well, what can your attorney do, and to be able to communicate effectively with your attorney to know, how best he or she can help you out. But at any rate, the three ways that we attack the facts of the case are: first, we attack the calibration. Basically, the way it works is unless anytime an officer does speed enforcement, that officer is relying on a machine to tell him that you're guilty. So if I'm running radar, this radar device puts up a number and shows, oh, they're going over the speed limit. If I've got LiDAR, it's a LiDAR device that shows that you're speeding. If I'm pacing, it's my cruiser's speedometer that shows what speed you're going. Any way you cut the cake, you're using a machine to prove somebody guilty of a criminal offense. Now, before you can do that, you have to establish a foundation of reliability. So we call this laying a foundation. You have to lay a foundation that that machine is accurate and working properly. In order to do that, you often use a calibration certificate. So unless the officer has personally calibrated the machine himself or herself, they must have a calibration certificate written by the person who did do the calibrations. So that calibration certificate is only admissible as evidence in court if it meets very specific criteria. And so there's a checklist of things that we look for when we look at a calibration certificate. So in any speed case, you ask to see the officer's calibration certificate for whatever device that they've been using. And you look at it. You look at things like how old it is, what format it is, whether it's been properly notarized, whether it states the proper attestations. There's even different rules for speedometer calibration certificates versus radar and LiDAR calibration certificates. So there's a lot of nuances. This is a surprisingly complex area of law, but it's the most common way that lawyers try to attack the legitimacy of a speed case. Everyone kind of knows about calibration certificates, though some of the things you're supposed to do with a calibration certificate or the things you should look for in a speedometer calibration certificate, that's always not as clear to people. But that's the most common way we attack a radar case. The second way is we attack how the officer used the machine. Now this is much more difficult to do. It can be extraordinarily effective if done right, but it's tricky business. It requires you knowing more about the equipment than the officer does, and on top of that, you have to know how to educate the court about the equipment or how to expose the problems in how the officer did his job. This sounds simpler than it really is. There's basically two ways that you show an officer did his job wrong. Okay, one is you hire a professional expert to come to court, and that expert explains to the court how radar works, how it should be used, how LiDAR works, how it should be used, whatever. But you have to pay about $1,000 to $3,000 to fly that person into Virginia, have them show up to court, put them up in a hotel. I mean, it's expensive because there aren't local experts here in Virginia. It's a national sort of profession, so you have to fly the person in. You pay them about $500 to $1,000 a day on top of their travel expenses. It's expensive. If you have money, great. Otherwise, you have to use the officer as your expert witness. So you have this officer who's trying to convict your client, and you've got to, by hook or by crook, get them to explain to the court what they should have done and then admit that they didn't do it, which is a tall order. If an officer knew how to do his job right, he would have done it right. So you need him to explain how he was supposed to do his job right, when in fact you're trying to prove he doesn't know how to do his job right. It's a tricky business. But if you know the stuff, if you know the equipment very well, and you're skilled in cross-examination, you're skilled in the legal proceedings, there's techniques that work really well. But you can see it's a complex area. It requires a lot of experience and a lot of practice. The first few times you go to court and try this out, it usually doesn't work out very well. It just is a big mess. It isn't until you've done it a couple dozen times, 3, 4 dozen times, then you start to get really good at it and you start to have more experience. But this is something that only comes with a lot of knowledge and a lot of experience. The third and final way we attack the evidence of a reckless driving case, the way we try to prove somebody's innocent, is with evidence of innocence. Okay? Now, most trials are about showing that they can't prove you're guilty. The burden is on the prosecution to prove that you're guilty. But sometimes we have evidence that you're innocent, and we present evidence. And so instead of attacking the evidence, we're presenting our own evidence. You can do this in reckless driving cases. Police dash cam videos, cell phone apps. Some vehicles